This is the number of positive cases in Malaysia. Okay, from 2005 to 2015. Okay, if you see here in 2014, there are 16. Okay, that's inclusive of Dato' Lee Chong Wei and Tan Su Jen. Okay, and it's not very alarming, it's manageable. It's just that the ADAMAS need to deal with certain sports. Okay, for here, from what we studied from 2005 to 2015, only two or three sports that constantly giving us problem. So we already deal with the sports association, and we really having tough time with bodybuilders. Okay, so half of our positive cases are from bodybuilding, and weightlifting. Okay, 28 cases. Okay, if you see, 2014, 16 cases, 8 cases from bodybuilding. Okay, 2011, 15 cases, 10 from bodybuilding. 2013, 8 cases, 6 from bodybuilding. So you really need to deal with it. Okay? Okay, as a conclusion, okay, ADAMAS, we really want to protect our clean athlete and zero tolerance against doping, creating a doping-free environment, and protecting the well-being of health and of athletes, preserving public health and morality. Okay, with that, thank you very much.
Thanks, Nishel, for the insightful and comprehensive talk on the good work done by ADAMAS. We have heard anti-doping from the perspective of the National Anti-Doping Organization. Now we'll be hearing the perspective of a lawyer instead. Please allow me to introduce the next speaker. He is Brian Song, who is the managing partner of Messrs. Song and Partners. He regularly advises Dato' Lee Chong Wei on endorsement and image right arrangements. He was also a member of the legal team for Dato' Lee Chong Wei in the Badminton World Federation doping hearing, which was held in Amsterdam in April this year. With that, I'd like to bring along our esteemed speaker. Please, Mr. Brian Song.
Afternoon, ladies and gentlemen. Thank you, Salim, for the introduction, and also thank you, Richard, for inviting me to deliver this part of the conference. I'll be touching on doping from the legal perspective. Doping is fundamentally contrary to the spirit of sport. It is a very serious issue, and every athlete has a personal duty to ensure compliance with the World Anti-Doping Code. The code took effect in 2004. It was subsequently amended in 2009. Further revision was made in 2013. That revision took effect on 1st January 2015. One of the key themes of the revision of the code was the longer periods of ineligibility for real cheats and more flexibility in sanctioning other specific circumstances. And under the code, there's provisions for what constitutes doping. I think Nishel has took everyone through this part, and I won't be going through this again. I'll just skip to the part on standard and burden of proof. Okay, the anti-doping organization has the burden of establishing that an anti-doping rule violation has occurred. This is a strict liability. It is not necessary that intent, fault, negligence, or knowing use on the athlete's part to be demonstrated in order to establish a violation. The standard of proof is comfortable satisfaction. What exactly is this standard of comfortable satisfaction? It is higher than a mere balance of probabilities, but lesser than beyond reasonable doubt. But towards which side of the standard does it tip towards? It is not quite clear to me, or in my view, because of the recent case which involves the accident football players. In this case, WADA appealed to CAS in respect of the accident football club players. Their hearing stems from WADA's appeal against the finding of Australian Football League Anti-Doping Tribunal that it was not comfortably satisfied that any of those players have violated the code. The tribunal cleared the players because it could not be comfortably satisfied that they were given substance. But WADA argues that the bar for comfortable satisfaction has been set too high. At stake is the question of the legal interpretation of comfortable satisfaction.